A Minnesota father is behind bars after police say he killed his own son. 16-year-old Manny Collins vanished 2 months ago, his disappearance sparking a desperate search, one that ended in a landfill. Authorities say Jordan Collins Sr. claimed he didn't know where his son was. But after searching his apartment, investigators found blood-stained garbage bags and multiple knives, DNA confirming the blood was Manny's. Now, Collins is charged with murder and could spend the rest of his life in prison. Thank you for joining us. I'm Kennedi Walker, and you're watching Law&Crime. Jordan Collins Sr. is facing murder charges after investigators found his son's body at a landfill weeks after the teen was first reported missing.
I assure you it's a sobering experience to work in a landfill like that only to discover someone else's child.
Investigators say 16-year-old Manny had been living with his dad when he went missing in May. According to documents obtained by Law&Crime, his mother reportedly told police Collins Sr. claimed Manny had gone to visit his great-grandmother and his girlfriend, but the teen never made it. Police later searching the apartment where the father and son had been staying. Inside, they say they found blood-stained knives in a bedroom closet and garbage bags in the living room that appeared to contain blood. DNA testing confirmed it was Manny's. After that discovery, investigators say Collins stopped communicating with police. Video surveillance then led them to a landfill in Elk River, about 30 miles from Minneapolis.
We were offered information that led to a video, and that video showed some evidence that would suggest the body might have made its way into a dumpster and into a garbage truck.
Search crews from multiple agencies spent weeks combing through trash. Eventually, they found human remains.
While conducting landfill search this past weekend, a human body was located. Further DNA testing was conducted, and sadly, the body has been identified as belonging to Manny Collins.
According to the medical examiner, Manny died from decapitation by knife. When Collins Sr. was arrested, officers say he had $1,300 in cash and they believed he was planning to leave the state. He allegedly told police the knives were used to butcher goats and sheep and that any blood in the apartment came from himself. He's now being held in the Anoka County Jail on $2 million bail. Prosecutors are asking the judge to consider aggravating factors in the case, including that Collins Sr. was Manny's father, that he was in a position of authority, and that the crime was especially cruel. The teen's family gathered to remember a life stolen too soon. Manny's family says they'll remember him not for how he died, but for the love he gave them while he lived. And here to break down this story with me is criminal defense attorney Jack Rice. Jack, thank you so much for coming on today.
Great to be with you.
So let's just jump right in. Police say that Collins stopped cooperating after the blood was matched to Manny. Legally, how is silence interpreted in cases like this?
Well, in this case, you can't use just his silence against him, but we realize there were lots of statements that were made prior to that. And so long as it appears that those are going to be admissible, that's going to be huge in a case like this, because anytime an investigation is being done, one of the first things that the police are trying to do is create a baseline. Where were you? What did you see? What did you understand? And what you're going to get now is inconsistency after inconsistency, and you get to use that against him. And that's exactly what's going to happen with the police officers involved in this case.
Yeah. And if someone does try to clean up a crime scene, like, hypothetically cutting up mattresses or tossing knives, does that count as tampering with evidence?
Yes. I mean, in a case like this is not particularly surprising that we would see something like this. I've handled murder cases involving stabbings myself, and so we have seen issues like these. And usually the tampering has more to do with the body than it has to do with the crime scene itself. And so that's more likely how they're going to be looking at this. However, the fact that he was involved in that crime scene, the fact that he was moving evidence around, that can be used against him too. So it cuts against the bigger question of the murder, that second-degree murder charge, let alone the tampering piece, which I really think has a lot more to do with the moving of the body from apparently this apartment into that landfill just north of the Twin Cities.
And speaking of that, like you mentioned, Manny's body was found in a landfill weeks later. How do prosecutors prove who put it there?
Well, in this particular case, it's really interesting because what the police did was something very smart, is they tried to determine that time of death, when he disappeared, and when this could have happened. Then what they did is they started looking for closed circuit television stuff. So they actually went around and they were able to determine that it appeared that there was a trash truck that came up behind that apartment on a certain date. And they then looked at that video to say, okay, this is what we're looking for certain kinds of trash, something big enough, bags potentially big enough that could hold a body or pieces of a body in this particular case. And then they know where that trash truck would have taken it and probably the general vicinity of what area within that area they would actually drop it in the landfill. And then they went looking for very particular bags of trash. So this is something where they could track from one space to the other to the other.
Yeah, very smart that they were able to do that and to pull that off, because if they weren't able to see that video footage, I mean, who knows, maybe we would still be looking for Manny to this day. We know as of right now no motive has been released yet. How much does that matter when prosecutors build a case?
In general, motive always is helpful, always matters. And the reason, and I say this because I've tried so many cases, one of the things that happens, and by the way, as a prosecutor too, is that one of the things that happens is when a jury wants to make a decision and they want to try to decide, is this person guilty of this? Is this person guilty of that? They want to make sense of it too. So is it an element of the charge? No, it's not. But what it actually does is it helps them understand why somebody would do something, what would drive somebody to make a decision. And in this particular case, this is a particularly brutal set of allegations. And so to say, could a father do anything like this? I think the prosecution would feel a lot better if they had a motive, but it's not necessary in every case, or frankly, any case, but jurors sure like it.
Right. And we know stuff like this unfortunately happens, but still just trying to wrap your head around the fact that a father could be accused of a crime so heinous. I bet that's tough. So how does a prosecutor frame intent when the alleged killer is the father and just not a stranger crime?
In a case like this, sometimes there's a lot of ways this can be done. Sometimes the way you will approach it is, who else but? Who else could have done this but this father? But in this particular case, what you have is a lot of evidence that they found. They found butcher knives. They found other large knives. They found massive blood stains. They found pieces of carpet that were removed, pieces of the underside of a mattress that were removed. And they even have statements from the defendant in this case talking about what it was that he claimed he did, including removing that piece of the bedding, that piece of the carpet, claiming that it was his own blood, when in fact, according to all of the forensics from the Bureau of Criminal Apprehension who's involved in this case, that in the end, it wasn't the defendant's blood in this case, but Manny's blood. You use all of those things to say location, opportunity, what could have happened, statements from the defendant. You use all of it to collectively create that probable cause.
Would prosecutors consider psychiatric evaluation here?
Yes, they would. And in fact, it's not just a prosecutor who could do this. In fact, and I again have had this happen in cases of my own on both sides, prosecuting and as a defense attorney. A prosecutor has the ability to request a psychiatric evaluation. In Minnesota, it's called a Rule 20. Defense attorneys can do the same thing. Judges sua sponte could actually, on their own, could actually say, you know what, I'm going to order one of these myself. And the allegations, which I know we've sort of danced around a little bit, the allegations in this case is that he decapitated his son, that he actually cut his head off. And the idea that if you're capable of that, what does that say about your mental state? Potentially, that may be something there. And that's something that we probably will maybe hear more about. Sometimes it's actually driven by the defense. But certainly, prosecutors have an obligation too. If they think that a defendant is simply not tracking, then they have an obligation to do so. Maybe just a twist, even if the defendant himself says, I'm completely competent, I'm completely sane, and I want to fight this. If a defense attorney, if their attorney believes that their client is incompetent, they also have an ethical obligation to come forward to the court, regardless of what their client wants, and actually say, we may have issues here.
Right. And given that decapitation, prosecutors want the judge to consider aggravating factors. How often does that strategy actually lead to a longer sentence?
Oh, it absolutely can happen. And this is particularly horrible, right? Right now, he's charged with a second degree murder. Now, that comes with a maximum 40 years to serve. Sometimes we see that. And what I mean by that is sometimes we'll see that second degree charge and it could be amended to a first degree. But second degree murder doesn't require premeditation. If what we get is more evidence, and sometimes you will see this, more evidence that says that we had premeditation. This was an intentional act, even slightly before. This was something that was planned and carried out. If that is the case, they could always amend up to a first degree, which in Minnesota could mean life in prison. So right now we're looking at a max of 40 years, but the potential for the upward. Or if they can amend to a first degree, you could be looking at life potentially. We don't have the death penalty in this state.
Given your experience, do you think that this could potentially be upgraded to first degree murder?
It could be. The one thing is, and I've had this happen to me directly, is that premeditation is a hard thing to prove sometimes, unless you have a witness that can establish it, or you get a statement that shows it in some other capacity, some other evidence that shows that, because you have to show that this was a pre-planned state. If what this was something that happened on the spur of the moment, but it doesn't take more than an instant to create premeditation too. So it's one of those things you want to make sure you get it. If they think they have enough, they could always amend, add that first degree. If they ended up in trial, you go to trial on the first degree premeditation. You go to trial also on that second degree intentional, or even a second degree unintentional. And so what you get are lesser includeds. And if the jury won't bite on the first degree, they can always come back on a second, or whatever they think is appropriate. That's how it works.
Well, going back to just the mitigating factors, how do prosecutors argue the position of authority piece? Is being a parent alone enough?
Yes. Yes, it is. In Minnesota, and this is true through most jurisdictions across the country, there are a lot of definitions of positions of authority, and that is actually one of the things they could use as an enhancing factor to make this worse, if you will. So sometimes you will see that it could be a parent, it could be a guardian. In other kinds of cases, you might have a teacher who's involved, or a priest who is involved, or a doctor who's involved, or an attorney who's involved. These are all somebody who can create a compulsion, who can force or make people think they're forced to do certain things. And so that's what will happen. And they could certainly use this as a parent, because a 16-year-old boy who goes to stay with his father, he certainly has not just an expectation but of safety, but also that he would be listening to his father. He's going to be dependent upon his father, which makes him particularly vulnerable. And that is really how a prosecutor would start crafting that enhanceability, that upward departure, is to talk about that vulnerability of a child.
Well, I know you mentioned that if he's found guilty of the second degree, he's looking at potentially 40 years. But if a judge does approve the aggravating factors, is that just automatically life?
No, actually, what you could do is you could go up further. But I mean, let's face it, if we're looking at age here, we're getting pretty close to that anyway. And yet at the same time, sometimes it's not about, if I use the term logic, right, about how far you will go, because why is it that we sometimes see in multiple murder cases where people will say, I want lifetime sentences consecutive? You're doing that sometimes because you're trying to make a point. And that point about any criminal case is that when you're sentencing in the case in front of you, but you're also sentencing for society as a whole, to say there are certain things that are beyond the pale. There are certain things that you should pay a higher price for. And the reason we're doing this to this individual is because we believe this is beyond what is even, if I can use the term, normal in this criminal world. And it's for society to see collectively. It's one of the reasons we do what we do.
Well, moving on to the defense strategy, if there's no eyewitness, how might the defense attack this case?
In a case like this, we don't have, at least it appears at this point, because we don't have all that evidence that's out there, we don't have a confession. And so the question is, was he working by himself? Was it somebody else who could have actually committed this act? And he was just there after the fact, cleaning up, if you will. I mean, there's a simple defense right there. That might make him guilty of the tampering charge, but tampering is inconsequential, relatively speaking, compared to the second-degree murder. So you could make the argument that that was an issue. There's a self-defense question, that he was defending himself and then afterward he panicked. That might mean that it's not a second-degree murder charge, it's something else. There's a lot of ways that this could go. And at this point, because the defendant did not admit, although he certainly spoke, and that sort of boxes him into some degree, because he did not admit to anything at this point, there are a lot of options that he may have in front of him.
Now, according to police, they found, blood at the scene. Could they argue, the defense argue, that the blood came from something else, maybe a household accident?
Right. Yeah, I mean, that's technically the argument that you could make. One of the examples, and this is something I would say as a defense attorney, one of the reasons that we always tell our clients not to speak to the police is because of what you and I were just talking about a minute ago, which is the sort of boxing in, that you can't argue something in trial later or subsequently to the events themselves, because you're kind of stuck with the things that you say, right? Or you're afraid that they might be manipulated. In this case, what they can determine is certain things. DNA, right? We have DNA in this case, and they're already saying that it wasn't actually the father's, not Jordan's. It was actually Manny's themselves. So they have DNA for identity. And those can be mixed up because of the biological connection, but you can absolutely make that distinction. So there's that issue. There's the potential amount that we're talking about. So we can talk about that issue too. So the identity piece is pretty clear. And remember, what we also get are the inconsistent, at least the allegations of inconsistent statements by the defendant in this case, claiming that he had cut himself. And in fact, apparently they came back and said, no, the blood that we found was of the victim of Manny, not his father, on the ground, on the wall, and some other places too.
Right. Well, if the defense does suggest mental illness, which we don't know yet, but if they do, how hard is it to get that to stick? Because we hear that more often than not, where people say, oh, well, they can just plead insanity because this is a case that's so heinous, something had to be wrong with them, but it's a process, correct?
Well, you're absolutely right. And I want to be really clear on this one. People will imagine, they'd say, oh, well, I'll use the colloquial, I'm crazy. I'm crazy. So therefore, it almost never sticks. Almost never. To use that standard, you need to understand just how serious we're talking about. Because in order for something like that to stick in a murder case, frequently, what you're talking about is somebody who is truly, truly disconnected from reality. And I've certainly seen cases like this where they don't know where they are. They're so disassociated with what's happened. And we've seen this with vets who come back with severe PTSD, who are having a flashback, and all of a sudden they're in the middle of Western Baghdad. That's what's in their head when something like this happens. And that's what they know. That's the kind of disconnect, the disassociation that we're talking about. Not that you have schizophrenia necessarily, although these are perfect examples of other mental illnesses that don't rise to the level of being incompetent or so mentally ill that you can actually help in the defense of your case. And those are slightly different from one another, but that's one of the things we think about too.
Well, given that, what happens if the jury, which doesn't agree on aggravating factors, which I don't know if the jury has any say in that, or if it's just the judge, could he get a reduced sentence?
It's certainly possible. I mean, I guess we're putting the cart before the horse just because we have all the evidentiary issues. Remember, in every criminal case, and this is just my experience over a long time, is there's always two fights at the same time. There's that pretrial fight about what comes in, what stays out. We're always fighting about evidentiary admissibility, right? Whatever comes in that a jury or the judge, the fact finder, gets to see. So however that plays out. The problem with a downward, as you just put it, this idea of doing less is really this, is that the allegations in this case are so horrendous, so heinous that they stick out to me. And I can say that just because after almost 30 years of this, when I have facts that stick out to me, they're going to stick out to everybody else too. And that's the jury, certainly, but it also is going to stick out to the judges. This is a case that's out of Anoka County, just north of the Twin Cities. And I mean, but it's still part of the metro area. These judges are sometimes more conservative than I'll see, more even aggressive sometimes than I'll see in other parts of the cities. And there's some very, very good, very smart judges. The judge who was handling this case for the bail argument, which she set at $2 million, extraordinarily experienced and really understands how this process works.
Yeah, the $2 million bail, I mean, does that just signal how seriously the court views the flight risk?
No question about it. And the prosecutor did a good job in explaining the fact that he had a lot of cash in his hands, right? And he had lied to the police, had done a whole lot of things. And you make this argument because there's always two issues we're looking at when it comes to bail, and this is true really anywhere in the country, is that whether they're a danger to society and whether they're going to reappear. Well, that danger piece really is something the prosecutor was able to highlight. And when they came in at the $2 million, that really says something, because you got to remember, in Minnesota, the court is obligated to set a non-conditional bail amount, meaning a cash bail amount in this case, no matter what the charge is. And so when you set it at a $2 million mark, you're really making the point that I'm going to set it so high that no matter what you have, you're not going to get out. So that's the equivalent. And that's certainly what this judge decided to do.
A minute ago, we touched on just the jurors and how they may be reacting to some things and how you felt about it when you read the details. I mean, just in cases where a parent is accused of killing their child, how does that emotionally play with the jurors? Because how can you go through the selection process and pick someone and they don't automatically have that bias?
Oh, well, they're gonna. I mean, I guess it depends on how we want to look at this, right? If I were prosecuting this case, my response is, of course they do, and we're going to make sure they do. I mean, that's what I want. I want a jury that is going to viscerally be outraged, not just by the murder of this 16-year-old, but by what was done to his body afterward. And I want them to imagine and feel the fear, the pain, the exhaustion, the brutality of what this is. I want it to be visceral. I want it to be personal. On the defense side, you have to lean into the fact that this is all of those things. And sometimes you're stuck with what you're stuck with. That's one of the difficulties when you're picking a jury ever, is that what you're really trying to do is you're trying to say to them, first of all, depending on which side you're on, please see where we are on this one. But it's also, from a defense perspective, is to say, how could a father do this? Any father do this? Because I think a lot of us would say, I can't imagine a parent doing this. I can't imagine any parent doing anything even close to something like this. And that might be a theory or a narrative that the defense, if they were to go to trial, may go down that path of, because again, that becomes a little visceral, and say, no parent who's not completely out of their mind would do something like this, and then establish that he's not out of his mind, and maybe a jury could make that connection. I mean, you never know how this will play. there's a huge difference between where we are right now, you and I, and if we're sitting in front of a jury of 12 and we start trying to figure out which of that jury pool we want to be that jury of 12.
Yeah. Well, this is a case that we will be following closely. Jack, thank you so much for coming on today.
Thank you so much.
Jordan Collins Sr.'s next hearing is scheduled for August 4th. A GoFundMe for Manny's mom has raised more than $23,000. For Law and Crime, I'm Kennedi Walker.